Welcome to The Explainer. Okay, today we are unpacking a dramatic legal showdown that pits a local business owner against a massive entertainment corporation. It is an absolute classic David and Goliath story, but instead of slingshots, the weapons here are commercial leases, constitutional rights, and literally centuries-old legal doctrines. We're looking at a fascinating case from the Constitutional Court of South Africa that basically asks one massive question that affects almost every business owner out there.
Have you ever just made a handshake deal? Or maybe you've taken someone at their word when they said, hey, don't worry, we'll give you a few extra days to pay. It happens all the time in business, right? But what actually happens when that casual verbal assurance clashes head-on with a strict, ironclad written contract? Well, that is exactly the dilemma at the heart of today's Explainer.
So here's our roadmap for today. We're going to start by looking at a very costly verbal promise, then dive into the harsh reality of an ironclad written contract. After that, we'll witness a total Hail Mary pass from ancient Roman law, talk about why you absolutely cannot skip the judicial line, and finally, we'll get to the final verdict.
All right, let's jump right into this first part and set the stage for our dispute.
Our conflict revolves around two parties locked in a pretty bitter battle over a commercial lease. On one side, we have the applicant, Crown Restaurant CC, who is leasing some commercial space, and on the other side, we have their landlord, Gold Reef City Theme Park. Now, Crown Restaurant fell on some hard times and ended up in rental arrears.
And the stakes here? They were incredibly high. The tenant fell behind on their rent by at least 71,000 Rand. Because of this mounting debt, Gold Reef City Theme Park basically said, enough is enough. They canceled the lease entirely and marched straight to the Johannesburg High Court to get an ejectment order to kick the restaurant out, plus an order to recover some specific funds.
But, the tenant, Crown Restaurant, they didn't just pack up and leave. No way. They fought back. They opposed the eviction by claiming they actually had a verbal side deal with the theme park. According to the restaurant, the landlord had verbally agreed to grant them an indulgence, essentially cutting them some slack and giving them extra time to put together a proposal to settle that massive rent debt. Because of this conversation, the tenant argued that the landlord had implicitly waived their right to just suddenly cancel the lease out of nowhere.
Okay, but here's where things get tricky, bringing us to how this verbal defense collides with the written word.
The landlord flat out denied that this verbal agreement ever even happened. But honestly, their main defense was the lease agreement itself. It contained what is known in the legal world as a non-variation clause. This is a strict clause explicitly stating that no agreement to vary, add to, delete from, or cancel the lease would be effective unless it was actually reduced to writing and signed by both parties. So think about it. Even if that verbal conversation did happen, legally speaking, it meant absolutely nothing because it wasn't on paper.
And it gets worse for the tenant. The theme park had a backup trapdoor in their contract. They pointed to another clause, often called a no preclusion clause. This stated that even if one party did happen to grant an indulgence or show a little leniency, it does not stop them from suddenly turning around and enforcing their strict legal rights whenever they want to. I mean, this contract was just bulletproof by design.
So, when the case goes before the High Court, Judge Misameki AJ looks strictly at these two clauses. And the judge agrees entirely with the theme park, finding that they were perfectly entitled to rely on the non-variation and no preclusion clauses. The court granted the relief sought by the landlord, effectively ordering the eviction of the restaurant. And to add insult to injury, the tenant subsequently failed to get leave to appeal at the Supreme Court of Appeal.
So what do you do when you're completely out of options? You pivot, bringing us to a desperate Hail Mary.
Facing the absolute end of the line at the Constitutional Court, the tenant's legal team tried to resurrect this incredibly obscure piece of legal history, the exceptio doli generalis. This is an equitable remedy rooted deeply in ancient Roman law. Historically, it was used as a defense to stop someone from enforcing a contract if doing so was just wildly unfair or unconscionable. The tenant essentially argued that, because of their verbal agreement, it was deeply unfair for the theme park to rely on those strict contract clauses. They literally wanted this ancient Roman concept reintroduced into modern South African law to save their business, claiming it aligned perfectly with constitutional values. But there was a massive, glaring problem with this strategy. In a famous 1988 case involving the Bank of Lisbon, the highest court of the time had definitively decided that the exceptio doli generalis was not part of modern law. In fact, the court expressly stated that they had buried it. It was legally dead. And despite a later Law Commission report in 1998 that discussed unfair contracts, no actual legislation had ever been passed to bring this concept back to life. Knowing this Roman law angle was a huge long shot, the tenant just threw an escalating avalanche of brand new constitutional arguments at the wall at the very last minute. For the very first time in this entire legal battle, they argued that relying on the strict contract clauses was unconscionable. They tentatively suggested that canceling the lease was an arbitrary depredation of property. And, in a move the court noted as not entirely intelligible, they even claimed that terminating the contract disrespected the tenant's dignity. Which brings us directly to a major procedural misstep, showing how the justice system actually functions as a ladder. Look, the court system is built on a very specific hierarchy. You start at the High Court, you move up to the Supreme Court of Appeal, and finally you reach the Constitutional Court. The tenant was trying to jump straight to the top rung of this system with brand new, complex, constitutional arguments that had never once been debated in the lower courts. And the Constitutional Court pointed out a fatal flaw on the tenant's strategy here. Back in the High Court, Judge Msamiki A.J. was only asked to look at the waiver defense, the argument about the verbal indulgence. He was never invited to develop the common law of contract to promote the Bill of Rights. He was completely blindsided because these massive constitutional issues about dignity and property deprivation were never brought up at the start. On the limited, narrow basis presented to him at the time, the High Court judge arrived at the completely correct conclusion. Because of this, the Constitutional Court firmly shut the door on this strategy, citing past precedents like the Satchwell and Fleecytex cases. They stated repeatedly that it is highly undesirable for the highest court in the land to sit as a court of first and last instance. If they rule on a brand new issue right then and there, there's literally nowhere else to appeal. It completely bypasses the entire judicial process. This builds perfectly into the court's core philosophy, which is captured in this quote from the Fleecytex case. The logic here is brilliant when you think about it. Justice requires arguments to be tested. When multiple courts look at an issue, the losing party gets an opportunity to challenge the initial reasoning. They can refine their arguments, rethink their strategy, and present a better case. By skipping the lower courts, the tenant was basically depriving the legal system of the proper exploration needed to adjudicate these massive, weighty constitutional claims. All right, let's wrap up this explainer by looking at the definitive conclusion of this legal thriller. Before handing down the decision, the Constitutional Court laid out some really clear guiding rules for anyone entering the legal system. First, the High Court and the Supreme Court of Appeal have a vital, irreplaceable role in developing the common law of contract. You absolutely cannot skip them. Second, litigants must properly identify their constitutional issues right at the beginning, at the exact time they institute proceedings. And third, all necessary material must be available to ensure proper adjudication at every single level of the judicial system. So because the tenant failed to follow these rules, failed to raise their constitutional issues early on, and tried to skip the vital steps of the legal hierarchy with a legally dead Roman defense, the final blow was delivered. The Constitutional Court ruled it was not in the interests of justice to grant the application. The application for leave to appeal was dismissed entirely by a unanimous court. The strict written contract reigned supreme.
Which leaves us with a pretty chilling final thought for every business owner, freelancer, or tenant watching this explainer today. The tenant in this case lost their business premises, not necessarily because the landlord was fair, but because a non-variation clause in a signed piece of paper completely trumped a casual conversation. So seriously ask yourself, the next time someone tells you, hey, don't worry, we don't need to put that in writing, is your next verbal agreement really worth the risk? Thank you so much for watching, and definitely keep your contracts close.